morning. Today is Tuesday, February the 12th, 2019. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Bohannon, will you please call the roll?
Dennis Bridges. Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, 5 of the 6 board members are present.
Thank you, Ms. Bohannon. We have a motion to adopt the meeting agenda.
So move. Second.
We have a motion by Clark McKinney and a second by Charles Rahm. We have the minutes. All in favor?
Aye.
Any opposed? Motion carries.
Motion to approve the minutes as presented.
Second. We have a motion to approve the minutes by Mr. Rahm and a second by Mr. McKinney. All in favor?
Aye.
Any opposed? Motion carries. Legal report.
Good morning, board members. The first item that we have on our legal report today is item number 2018-07-9601, which is a complaint against a funeral director with no disciplinary history. This is a consumer complaint alleging the respondent overcharged the consumer for her husband's funeral services. Specifically, the consumer claimed 1. The respondent charged her additional money for basic services over the price listed in the pre-need policy, and 2. The respondent failed to reimburse her $259.98 for a mausoleum space payment. Specifically, when the consumer's husband died, the cemetery provided a payoff amount of $3,379.95, which the respondent was to pay, and then insurance would reimburse her. However, after the respondent sent a credit card payment for the payoff amount, the cemetery realized it had taken an additional monthly payment out of the consumer's account. As such, the cemetery charged the credit card $3,119.97. Despite this, the respondent received money from the insurance company, which includes the $259.98 difference between the payoff amount and the charged amount. In response to these allegations, the respondent stated she would not reimburse the consumer the $259.98 because 1. Her staff worked at the viewing/visitation from 9 a.m. to 8:45 p.m. 2. The consumer was not charged for the use of limousines for the viewing/visitation. The consumer indicated the respondent sent these on her own. And 3. She gifted the consumer a casket. The respondent additionally told our investigator that she did not charge the consumer for the casket, limousines, or extended visitation time because the deceased had been her employee for years. Notably, the statement of funeral goods and services was provided, which showed the consumer was charged $395 for use of facilities and staff for viewing. The pre-need policy was also provided. It was executed by the deceased and the respondent in 2003. Legal's recommendation here would be authorization for a formal hearing and authorization for a civil penalty in the amount of $750 to be reduced to $250, provided the respondent refunds the excess funds in the amount of $259.98 to the complainant and provides sufficient proof to the satisfaction of the department within 30 days of the consent order's receipt.
know if the respondent owned the facility where the mausoleum space was located, or was that an independent third-party transaction?
That was an independent third party.
Motion to accept recommendation.
We have a motion to accept by Mr. Rom. Do we have a second?
Second.
We have a second by Mr. McKinney. All in favor?
Aye.
Any opposed? Motion carries.
The next item on the legal report is complaint number 2018-088-301 against an establishment with no disciplinary history. A former employee of the respondent establishment filed a complaint alleging the respondent was aiding in unlicensed activity. Specifically, the employee alleged that he was the only licensed funeral director at the establishment, but after he was suspended, the respondent may have met with at least one at-need family and 2 cremations were performed. This case was sent for an investigation which revealed no evidence of unlicensed activity. A licensed funeral director was present. The recommendation here would be to close.
Motion to accept council's recommendation.
Second.
We have a motion by Mr. McKinney. We have a second by Mr. Robert Davis. All in favor?
Aye.
Any opposed? Motion carries.
The next 2 items on the legal report should be considered together. The first complaint is complaint number 2018-09-0281 against an establishment with no disciplinary history. And the second complaint is complaint number 2018-09-0301 against a funeral director with no disciplinary history. Respondent number 2's funeral director and embalmer licenses expired on September 30th, 2018, but he did not meet the requirements for reinstatement of those licenses until October 26, 2018. Despite this, during that time, respondent number 2 remained a manager of record for respondent number 1, and 18 services were conducted at the establishment or other facilities. In response to these allegations, respondent number 2 apologized for letting his licenses lapse and overlooking renewal. Legal's recommendation would be a letter of warning against respondent number 1, the establishment, and a letter of warning against respondent number 2, the funeral director.
Motion to accept council's recommendation.
We have a motion by Mr. Shackelford. Is there a second?
Second.
We have a second by Mr. Rom. All in favor? Aye. Any opposed? Motion carries. Thank you, Ms. Gino. On to the director's report, Mr. Gribble.
Thank you, Mr. President. Good morning, board members. First thing to look at today is the legislative update for today's meeting. We have several bills listed that are either directly affect or indirectly affect the Board of Funeral Directors and Embalmers. And I will email you this update and also the attached bills. I'll email that to you individually later today, so you'll have the information later if you want to retain it. First is House Bill 0048, Senate Bill 0856, regarding embalmers. As introduced, authorizes lawful permanent residents of the United States to apply for an embalmer's license, changes the requirement that an applicant for an embalmer's license have obtained an Associate of Arts degree to an associate degree. This would affect Section 62-5-307. Next bill is Bill 0432, House Bill 0967, regarding funeral directors and embalmers, and as introduced, authorizes operators of crematory facilities who provide free services for cremation of human remains to receive a refund of the permit fee, which was paid for such services. This would amend chapters and titles, but it'd be relative to operators of crematory facilities. Senate Bill 1041 and House Bill 1431 regarding funeral directors and embalmers. As introduced, expands the definition of cremation for the purposes of regulating operators of crematory facilities to include additional processes such as alkaline hydrolysis. This would amend Title 62 in Chapter 5 relative to cremation. House Bill 0520 and Senate Bill 1431 regarding professions and occupations. As introduced, allows a HISET diploma to fulfill education requirements for licensure or registration of funeral directors, embalmers, and their apprentices. This would amend different titles, but in particular Title 62 regarding the funeral board. House Bill 0304, Senate Bill 0386 regarding licenses. As introduced, exempts members of the armed forces stationed within the state and their spouses from licensure requirements to practice professions and occupations regulated by the Department of Commerce and Insurance and Department of Health, subject to meeting certain requirements to practice. Of course, the effective part here would be Title 62. Embalmers. Senate Bill 0196 and House Bill 0261 regarding state government, as introduced, makes various changes to the Right to Earn a Living Act, including requiring entry regulations, public service restrictions, and statutes to be discriminatively necessary and carefully tailored to fulfill a legitimate public health or safety objective, and allowing persons to petition applicable licensed authorities and bring civil actions when such standard is not met. This would also amend Title 62, which would be regarding the Board of Funeral Directors and Embalmers. Senate Bill 0602 and House Bill 0785 regarding trust, as introduced, authorizes a trustee to establish a single trust fund for all pre-need fund contracts issued by multiple pre-need sellers instead of having to establish a trust fund for each pre-need seller. This would amend Title 62 regarding the Borough Services section. House Bill 0650 and Senate Bill 1173 regarding insurance companies, agents, brokers, and policies. As introduced, allows the owner of a prearrangement insurance policy and not just the beneficiary to irrevocably assign the policy or policy benefits to a funeral establishment if the insurance company issuing the policy does not offer a funeral trust or only offers a funeral trust for an additional charge. This would amend Title 62, which is relative to burial services. And each one of those bills is on your iPad as they were introduced. If you have any questions about those, probably Ms. Hooper can answer those better than I can. If you want to, I'll pause for a minute and see if you have questions regarding any of those.
This right to earn a living, was there a bill like this last year or something similar to it? Do you recall?
I'm not sure if it was last session, but the Right to Earn a Living Act did pass, and there were various aspects of it implemented here at the department within the last year.
Has the department done any investigating about what other states are doing regarding the alkaline hydrolysis process? No, this is relatively new, something that's came up within the last 10 years. Do you all know if this bill is consistent with what other states are doing, or is this something completely different?
I have not personally researched that issue to look at what other states that do allow alkaline hydrolysis, how they have implemented that in their statute. So I can't say that that research project has taken place. It's possible that others within the administration may have reviewed this information, but I couldn't confirm that.
Thank you.
Is this bill similar to those that have been introduced before?
It was several years ago when the first one was introduced, and to be honest with you, I don't remember. It's probably been 8 or 9 years. They were two in the Chattanooga area that were interested in doing having an alkaline hydrolysis operation in that area, and they went to their state representative at that time, and there was a bill introduced, but I don't remember. That particular bill obviously didn't pass, so I don't remember exactly if this is similar to it or quite.
Do we know the timetable before it goes to committee for discussion?
I can probably look up that information. It may be online. I'll look for that now.
It just seems Mr. Rom may be thinking the same thing. It just seems that cremation has always been is by heat and fire, and alkaline hydrolysis is just the exact opposite. It's water chemicals. I think the two dispositions ought to stand on their own merits. I wouldn't want to confuse the public thinking that they're going to get one thing and then wind up having something else, another process done.
So we've checked online, and it looks like it's been introduced and passed on first. Bless you. Looks like it's been introduced and passed on first consideration. We don't see any calendar dates online yet. You all can track this bill, and you certainly, if you have concerns, can discuss that today and decide, whether the board wishes to take a position and take any action communicating regarding this bill.
Mr. Gribble, do you know where the two state associations, where they stand on any of these bills, the Tennessee Funeral Directors Association and Tennessee Funeral Directors and Morticians Association? Have you heard anything from them regarding any of
bills
these?
in general? Well, I think some of them, at least two of the bills, and Mr. Batson's here, who's the executive director, he could speak to that better than I can, but I think at least two of those bills are bills from the Tennessee Funeral Directors Association. Batson specifically which ones, well, you could address that to him.
Asking which two of the bills are sponsored by the association, or are supported by the association?
Tennessee Funeral Directors Association. TFDA has two bills in this year. The first one is just a language housekeeping that we talked to the state about with the Associates of Arts degree. Just drop the arts and have associate's degree, because I think Gupton and maybe one more in the country has the only one with the arts behind it. And the other part to that was the legal resident, legal resident of the United States, instead of, what's the present word,
Citizen.
Robert, do you remember?
Citizen of the United
Yes,
States.
So they changed that because apparently they've already approved some folks that that are not citizens, but they are legal residents, so just a housekeeping thing. The other one is the trust bill, and we've had it in for a couple of years just to kind of test the waters on it, where funeral homes will be able to take pre-need money on trust and combine that with other funeral homes establishments, put them in, be accounted for separately, but they'd be able to put those together just to increase the interest rate and the return, and better than what most people with insurance are doing now. That's what we have.
I'm sure your committee is aware of these other bills, and have y'all had time to look at those and decide where the association stands at this point?
The only one we've talked about, I've talked with some of the members, was the alkaline hydrolysis bill, and everybody's in agreement that needs to stand on its own. And there are several states out there that have legislation now. I know Ohio's one of them. I think Oregon's another one. Florida's another one. So I think between those states that are working those laws pretty well right now, we can, if not just take one, maybe we can take what we think is the best of each. So I think there's enough information out there now to construct an amendment to the current bill, which is actually the kind of caption bill, but to put that together where it would alkaline hydrolysis would stand alone, because like you said, it's not cremation. It's the polar opposite of cremation. So it really, in my opinion, it stands aside.
Needs to stand on its own merits.
Yes, absolutely. It should be the cremation section and alkaline hydrolysis section, as
Right.
far as I'm concerned.
Okay.
Anything else?
Regarding Senate Bill 196, is the burden of proof regarding requirements for entry into a profession on the regulatory board in question. It appears, just in my brief review of the bill as it's presented to us today, that if an individual believes that a certain entry requirement is prohibitive to them, that they can petition the regulatory board in question, and the regulatory board then must respond and either repeal or alter that particular entry requirement, or state its case, if you will, for why it believes that is important to the public safety and well-being of practitioners and consumers. Do I understand that correctly, that the board does have the burden of proof, if you will?
The board would need to be able to show that any and all laws and regulations are both demonstrably necessary and carefully tailored. And so that, I think, addresses your question. Those showings would need to be made by the licensing authority, which in this case would be you all, if a challenge were to arise.
This pertains to rules, is that correct?
Both statutes and regulations. One thing I don't think I said earlier with the standard under that bill, it's demonstrably necessary and carefully tailored for public health and safety. So I did want to add that qualifier. And that's for Senate Bill 0196, House Bill 0261.
Watson, does the association's legislative committee have plans to address these other bills in the immediate future?
Yes, absolutely. Sorry, Bob Batson, Tennessee Funeral Director Association. We have a conference call every first of every month. Of course, it's being about close to the middle of September, the next 2 weeks. We'll have another one. We'll have also have a board meeting 1st of March. So before this goes through, we'll have that. But we have a lobbyist that's watching all these. And matter of fact, that's just what I was doing right there, keeping everybody apprised of that. That'll go out to all our members today. Government Affairs Committee members.
Of my ignorance, but what is a high set or diploma as contrasted with a GED?
I'm glad you asked that. I didn't want.
I've never heard of
I
that,
didn't
so-
want to appear to be more of an imbecile.
I'll step out on the line for you there.
Me either.
I've just never heard that terminology. I'm not familiar with it.
Give me 1 second. I did want to.
See, she doesn't know either.
I have, my ideas, but I wanted to be pretty specific in answering your question. So essentially, it's a high school equivalency test, and how it compares to the GED, I wouldn't be able to discuss that because I've never actually reviewed it, but it's another high school equivalency test that's not the GED that's permissible for individuals who didn't graduate high school.
Thank you.
Is that in relation to homeschooled children?
It's a way for people who didn't finish high school to earn a diploma, and so individuals who are homeschooled, many of those individuals do earn diplomas, so I wouldn't say it's necessarily connected to homeschooled students.
State for the record that I do have some concerns about Senate Bill 196 and House Bill 261. Let's face it, does appear to at least offer a mechanism whereby certain licensing provisions could be abolished over time. Certainly that is a concern, I think, as far as the public safety is concerned.
I think it could possibly open up a can of worms. I can in some ways understand the part about the rules and regulations, but I don't understand the part about the statutes, because why would they be wanting to pass a bill that could possibly knock down a statute that the legislature passed themselves? That doesn't seem to make any sense. But I agree with your comments. Because if I understand Ms. Hooper correctly, the burden would be on the board to justify a statute. Is that correct?
So it would apply to statute, regulations, and restrictions, and the licensing authority, in this case, you all would need to be able to demonstrate that whatever is at issue is demonstrably necessary and carefully tailored to fulfill a legitimate public health and safety objective.
Is an issue that cannot be resolved between the regulatory authority and the petitioner, that winds up being settled by a civil court judge.
Yes, it does create a right of civil actions and also authorizes damages if the petitioner in that case prevails.
And damages against whom? The state of Tennessee? The board? Goes back again to what I said. Why would I can understand a rule passed by the board, us being responsible for that, but how can you hold the board responsible for a statute that was passed up in the legislature?
As far as the logistics of who would actually pay the damages, I'd have to do further research, but it would be damages against the state, and I would have to review exactly how those damages would be paid if a petitioner were to prevail under this act if it did become law.
Just a side comment, I can see Senate Bill 432, I can see that being a nightmare for the Department of Health. Having to refund permit money. Again, is that, it says, when they don't charge, well, what about if somebody does a cremation and never gets paid a penny? Is the establishment going to be able to go back to the Department of Health and say, hey, I never got paid for this service, I want my $25 back? I don't guess that was a question, that was more of a statement.
I certainly would encourage each of us to be in touch with our representatives and senators and discuss these bills with them and give them any concerns that we have.
On that point.
Regarding Senate Bill 196 and House Bill 261, does the board wish to consider taking a stand on that particular issue based upon the information that we have available to us today? As our charge is to protect the consumers of the state and not to be a facilitator to guarantee ease of entry into the profession that we regulate. That might be a consideration for us to think about taking a position on that particular bill based upon how it's been presented to us today. Or do we wish to gather more information before we consider taking an official position on the bill?
Gribble, what types of, has the board taken positions on pending legislation before, and if so, how did they go about that?
I can speak for the Board of Funeral Directors and Embalmers, and then Ms. Hooper can probably speak for other regulatory boards. In my time that's been here, the board has taken the position that they will contact their legislators individually. Past boards have. That, like Mr. Rahm was talking about earlier and Mr. Duffer was talking about, if you feel strongly individually about something, then you contact your own legislator or other legislators about that. In the past, the board the Board of Funeral Directors and Embalmers has not taken an official position to support or oppose any bills, but deferred to the legislature as what they do about that. But other regulatory boards, to my understanding, may have done differently.
I would agree with Mr. Gribble, and I've also seen boards vote upon a designee to represent the body and testify before committees and that sort of thing. And the reason why there has to be a vote is because you all, obviously, as individuals, don't have the authority to speak for the board unless the board itself, and that's you all, designate a particular individual. And so I've seen that in the past.
I was just going to say, Mr. Shackelford, to your point, if the board wants to take a position or designate a person, you may want to consider doing that at this meeting, because our next meeting would not be until March, and there could possibly be quite a bit of traction on some of these bills between now and March. Might not be, but could be.
Certainly agree with Mr. Rahm and Mr. Duffer that each individual on the board should certainly make contacts where they think it appropriate, as long as it is clear that they do not intend to speak for the board as a whole. And I'm certainly comfortable with that. If the board does not wish to take a official position on the bill, I'm certainly comfortable with each individual member contacting their legislators to discuss any concerns they might have.
I'm not sure which would carry more weight. 6 members reaching out individually and or the board speaking as a united.
Was just in the way I would consider your question, Mr. McKinney, if each individual member reaches out to their representative and their senator, then you've contacted, considering Mr. Bridges in this equation, you've contacted 14 people. But if you take a position as a board, I would assume that that position would be communicated to the body as a whole in some manner, but I'm not certain how that process would work.
That's an excellent point.
We would probably name you to go speak to them.
Not looking for any additional job. You've already stuck me with a continuation. Strike that from the minutes.
I'm fine with each individual member making their opinions known, and since it has not been a practice in the past for this particular board to take a stand, I just think we'd probably at this point be better off just to let it go.
I would agree. I think that, if all of us shared our position, I think it would stretch across the state of Tennessee, and then we would be able to get our voices heard.
And those that are members of associations can make their opinions known to the association too, so that they can carry the message.
Exactly.
Yeah, I agree with that.
The Funeral Directors Association and the Mortician Association, they tend to carry quite a bit of weight. So.
Well said. Any other questions, comments to Mr. Gribble in regards to the 8 bills? Mr. Gribble?
Next would be the licensee report. The report of license administratively approved by the Executive Director pursuant to Board authority for the period of January 8, 2019 through February 11, 2019. You have the funeral homes listed there and the individuals listed as well. Closed establishment report. There's one establishment that's reported closing since the last meeting. That's Hardwick and Sons Funeral Home Incorporated, Tremel Chapel, located at 913 East M.L. King Boulevard in Chattanooga. Disciplinary action report. It's a report of consent orders that have been administratively accepted or approved by the Executive Director pursuant to Board authority and as reported on the December 2018 Regulatory Board's disciplinary action report. You have a list of those there. It's a complaint report. As of yesterday, there were 21 complaints regarding funeral directors and/or embalmers, and 22 complaints regarding establishments, for a total of 43 complaints that we had. President, that concludes my report.
Thank you, Mr. Gribble. Do we have a
Motion to approve Director's report.
We have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Rahm. All in favor?
Aye.
Any opposed? Motion carries. On to the approval of license applications.
There are no individuals to appear before you today, and there's one establishment. The establishment is Simple Cremation Solutions. Looks like I have a typo there, and that's my fault. Jeremy Arnold Price is to be the manager. It's located at 90 Dogwood Lane in Somerville, Tennessee. It's a new establishment. The ownership would be a limited liability company owned by Fett Investment Company, LLC, 18020 U.S. Highway 64 in Somerville, Tennessee. It's my understanding representing the ownership today would be Mr. Michael Tillman, and representing the manager would be the manager himself, Jeremy Arnold Price. Gentlemen, if you would introduce yourselves for the record and make whatever opening statement you'd like to the board.
Michael Tillman, I'm the owner of Fayette County, People's Fayette County Funeral. I want to, personally, before we get started, I just want to thank each of y'all as board members for what you do, the dedication and commitment for our profession. I want to thank y'all for that. Y'all probably don't hear that enough, and I really respect you and thank you for that. And this is Jeremy Arnold.
My name's Jeremy Arnold. I'm manager there at People's Funeral Home, and certainly want to thank you for your time and opportunity today. Thank you.
Peoples Fayette County Funeral Home currently has a crematory, correct?
That is correct.
Okay. This location would be in relationship to that facility.
About 7 miles apart, opposite side of the city.
This is a storefront operation.
It's a separate building altogether, located behind our Peebles Fayette County Funeral Home's main chapel, directly behind it, separate building.
Business office, I would call it, is located now.
That is correct, yes, sir.
Scribble all the paperwork in the office, as far as the office concerned, is in order.
Yes, sir.
Okay. Make a motion, we approve this application.
We have a motion by Mr. McKinney. Is there a second motion?
I'll second.
We have a second by Mr. Rom. All in favor? Aye. Any opposed? Motion carries. Congratulations, gentlemen.
Thank you, sir. Thank you all again.
Moving on to new business. We have any new business? Motion to adjourn. We have a motion by Mr.
Just one
McKinney.
second, Mr. Duffy.
Have a motion to adjourn by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Davis. All in favor? Aye. Any opposed? Thank you, gentlemen. Thank you.